Reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes.
Okay, you may proceed.
May it please the Court, my name is Ted Galatis. I represent Walter and Lynda Walz, who are seated behind me in the back row. Briefly, in 1982, Walter and Lynda bought a lot with a single-family home according to an original survey and an original plat that was recorded in 1957. The property is in Broward County. It's called Coral Heights Section 2, and it's just west of US 1 between Florinata, 45th Street, and 40th Street. There's 331 lots in that subdivision. As I said, it was platted and surveyed in 1957. And Walter and Lynda bought their home in 1982. 30 years later, in 2012, John and David bought their home next door to Walter and Lynda, and they bought their home by warranty deed, and again, according to the same original survey and original plat. In fact, everybody in Coral Heights Section 2, 331 homeowners, bought their lots and their homes according to the very same original survey and original plat. After John and David's purchase in 2012, they sued Walter and Lynda, seeking to take a 4-foot section of their lot. In summary, there is absolutely no legitimate legal basis for John and David or anybody else to take any part of Walter and Lynda's property without compensation. And that's why we're here today.
Was there any dispute that the surveyors made a mistake when they did the original plat? And that there was a 4-foot mistake made in the, if you use the meets and bounds, for lack of a better term, the things, the original spikes that were used that laid out the plat. It appears based on the testimony that both the surveyors for each party agree that there was a mistake made.
There is. It's clear on the face of the plat. If you measure the distance from here to here where these 6 lots are, where the plaintiffs and defendants live, it says on the plat 270 feet. But if you look over here on 45th Street, the identical blocks and the identical distance says 274 feet. So, clearly there was an error in the original plat. But that error and the law of surveys, and this is in order to maintain the integrity of neighborhoods, the law of surveys since the Supreme Court of Florida in Aiken v. Godwin in 1951 said that the courts must overlook those errors, and subsequent surveyors cannot come in and correct errors of a platting surveyor. Otherwise,
but I thought that it's where the marks are. You can correct them if you use the original marks. You can't change the plat map, but if you go back and you look at the original marks, the rocks and the stakes, whatever it is they use, going back to England 500 years ago or whatever it was when they started this process of surveying, you're allowed to go back and look at the original marks. And if those original marks are not moved, and you use those original marks and there is a mistake, you can correct it on the plat.
what the law says is that the original monuments placed by the platting surveyor, when they vary or differ from what's on the written plat, you ignore the written plat and you follow the marks, the monuments.
And isn't that what was done in this case?
What happened in this case, they did find one original monument, which was at the other end of the block on lot 14. So we have 14 through 19. They are 18, we are 17. The surveyors all found an original monument down here at the end. And it clearly varied. The distance was 274, not 270. So it supported the fact that there's an error in the plat. But the way the lots were laid out from east to west, lot 19, according to the plat, is 100 feet. Lot 18, 90 feet. Lot 17, 80 feet. And then the rest of the houses are 80 feet down to the corner lot, which is 14, where that original monument was located. And we located a historical survey. It's in evidence. It's in the exhibits attached to the appendix to this appeal from Hugh Davis back in 1959. And he noted on the survey of Lot 14 that the distance between that point of curvature, which is a monument, they found it buried in concrete, steel rod, the distance from there to the edge of the lot 14 is 23 feet, not 19 feet as shown on the plat. That's in evidence. The plaintiff's surveyor tried to put the 4 feet on lot 19 at the end next to them, which in effect shifts everybody 4 feet. So we end up not with a 80-foot lot that we've owned since 1982, but a 76-foot lot if the final judgment ejecting us from that 4 feet is upheld. There is absolutely, it's speculation where the 4 feet actually is down at the other end of the lot on lot 14, and that's in the surveys, and that's what our surveyor expressed. So I think that answers about the monuments. Monuments control over paper. The courts do not want to force homeowners to move boundaries that are long established just because there's an error in the plat. They would rather change the paper than move homes. And that's the crux to this case.
Would your clients be gaining 4 feet on the other side?
No, they would not. Not by this final judgment. It simply ejects them from 4 feet on the eastern side of their lot 17. It shifts. What's happened here is they've trying to change a plat. They're trying to correct the plat error with a survey. And Florida law, going back to the 50s, and the Supreme Court of Florida said, no, you cannot do it. Even the government can't do it. The government platted, or not platted, but surveyed a lot of the land in Broward County back in the 1800s. If you bought land based upon that original government survey, the government has been prevented from going back and correcting the original survey and disenfranchising or taking property from legitimate owners. The courts have held that the mistakes of the original surveyor are the mistakes of every subsequent surveyor, and it's not appropriate to change a plat based upon a survey or a resurvey. Remember, it's the original survey that controls.
One of the cases that the appellees cite in the brief is Tyson versus Edwards out of the 5th District. I noticed you didn't have a response to it in a reply brief, but I'll just read a quote from it, and I'd like to hear your response to it. Written plats are not construction plans to be followed to correctly reestablish monuments and boundaries. They are as-built drawings of what has already occurred on the ground and are properly used only to the extent they are helpful in finding and retracing the original survey which they are intended to describe. And to the extent the original surveyor's lines and monuments on the ground are established by other evidence and are inconsistent with the lines on the plat of survey, the plat is to be disregarded. When evidence establishes a discrepancy between the location on the ground of the original boundary survey and the written plat of that survey, the discrepancy is always resolved against the plat. Why doesn't that apply here?
It's a lot that you just cited from that case, but my understanding of Tyson v. Edwards is that you disregard the lines as drawn on the plat, and if the monuments support some other boundary line, then you hold the boundary lines. Now, I'm not so sure Tyson even applies here. I mean, there's one monument.
Let me back up. Isn't that exactly what their appellee's argument is?
No, appellee's argument is that their surveyor located a scrivener's error in the plat, which we all agree exists, and we corrected that scrivener's error by adding 4 feet to lot 19, which is right adjacent to us, next door. So they're making lot 19, if I misspoke, I may have said 14, lot 19 is next door. Their surveyor says you add that 4 feet to lot 19, which shifts their property lines or their boundary line by 4 feet.
Well, why didn't you, I mean, it seems to me that my question came from that quote, because it seems to me that when there's a conflict between the monuments, the survey that's taken from the monuments versus looking at a plat, the monuments win over when there's a conflict. That's what that case seems to say to me. why, if in fact, if you accept that principle, then wasn't your remedy to go and sue all the neighbors so that the line would then be, the plat would be fixed so that everybody's property line would be adjusted accordingly? And that I think you indicated that the person at the very end of the street was the one who was really going to lose the 4 feet.
Yes.
So wouldn't the remedy have been to go and bring everybody in, have the whole thing using the monuments, have everything resurveyed, and move everybody's property line 4 feet over, so your client would have lost 4 feet on the plaintiff's side, but would have gained 4 feet on the adjoining neighbor's side, and gone down the line until the person actually shouldn't have the 4 feet is his property or her property lines properly adjusted.
Well, Judge, I did suggest to the trial court that all the property owners to the west of us should have been proper parties because they are interested parties. That is, if the plaintiffs prevail, now we have to shift, we have to sue the neighbor Benson, Mrs. Benson, who's sitting back there, and Mrs. Benson's going to sue Mr. Carasola, and Mr. Carasola is going to sue the neighbor on lot 14, and it is 14 that would lose. But I don't think Tyson v. Edwards stands for the proposition, really, that where you have long-standing improvements and they were built based upon an error in the plat, you don't disturb the boundaries as set up and laid out by the original surveyor. It's too disruptive to a neighborhood. For instance, if my clients move their lot line 4 feet to the west, their fence line would be 3 feet from her bedroom windows, Mrs. Benson. Likewise, Mrs. Benson, who has 7 feet on her west side of her home, would now be 3 feet from Mr. Carasola's home. Tyson v. Edwards says you don't move all the houses. You ignore the error in the plat. You go with what's built on the ground and what's monumented. The monument only establishes that there is an excess 4 feet. We put on evidence, and the uncontroverted evidence from the 1959 survey was that 4 feet is down on lot 14. There was no competent substantial evidence to allow this survey to reline the boundaries. The boundaries are as they have always historically been held.
You tried getting an adverse possession jury instruction, and the trial court said he rejected it as drafted, or I forgot if it was a he or she. Did you try to bring that up at all after that?
Well, Judge Forrest, I brought it up in the JNOV, in the motion. The judge found that I basically overlooked it. I submitted an instruction on adverse possession. The appellees submitted an instruction. During the charge conference, which was the last day of trial, late in the afternoon at 4:30, we both overlooked that it didn't get into the jury instructions. I overlooked it as well. I raised it as a point on appeal because certainly I pled as affirmative defense adverse possession. We own the property since '82. We openly and notoriously maintained the property up to the chain link fence line that divided these two lots for 50 years. This house was built in 1958. So the house and the improvements had been there since the late 50s. So I pled adverse possession. The court overlooked giving an instruction on it, but we had an interrogatory form of verdict, and the very first question was, do the plaintiffs own the disputed 4 feet? And by their answering in the affirmative, that took out all of our defenses, basically. So, but the law was not properly applied by the trial court because the...
All right, thank you, Counselor.
Thank you,
Your
Your Honor.
rebuttal time, I'll give you an extra minute.
Okay.
Thank you, Your Honors. Robert Hartzell for the appellees. Let me just quickly address the arguments that Mr. Galatis has presented to you just now. These are factual issues. You're right, absolutely right. Tyson is controlling. Tyson's on point, all four corners. That case is identical to this case. This case was a 5-day jury trial in which we had 6 different experts testifying. They had their surveyor come in. Their surveyor agreed with us that the original monuments, what Tyson tells you to do, the original monuments, when you shoot the transects, all of a sudden you get the proper plat. What's supposed to be done is done through using the markers, and that's why they say use the monuments on the ground. They went out and they did the survey, and when Mr. Allison's survey came in, it says, here's per plat and here's per occupation on his survey. He understood that the plat had an error in it. And what it was supposed to be, when you went out there and physically shot it with a transit, you figured out where all the errors were. You figured out where the plat had a mistake, okay? So he agreed. Our surveyor went out there, found the same error. Everybody agrees. They all met together, and they got in a group, and they all agreed. And Mr. Allison, their expert, came out and said, you know what? I'll change all the non-permanent monuments to coincide with all the rest of them, with the actual permanent reference markers, okay? They had Mr. David Sammons, Mr. Robert Sammons, and Mr. Clyde McNeil all looked at the surveys, all went out there, they all found the error, and it was more than one permanent reference marker. The testimony of David Sammons, he went all the way out to the other street, and he found another marker, and he was able to shoot all of his transects to figure out exactly where all the errors were, where every plot of land was supposed to be, according to the monuments, not the plat. Of course, as Tyson says, we use the plat to find where monuments might be, but then they go out in the field. They actually physically replicate that thing using those monuments.
What's your position on adverse possession? Is that sort of the way that this gets resolved, if it were preserved?
It's a good question. The adverse possession, when we went and we argued it during the charging conference, I was arguing the standard statutory language. He was arguing the DAD case, the recent DAD case out of the 3rd DCA. We argued it. He presented the case to the judge. He presented his language to the judge for the jury instructions. The judge looked at it, and we put the quote in our reply brief, and we say, hey, you can see where the judge is saying, just go back and fix your draft. You can't have I'm not putting handwritten chicken scratch with case names and instructions to the court to the jury. They gave it to him. He did nothing with it. He goes, forget it. That was exactly like this, forget it. And he put it aside. Also, there was another instruction which they gave up on too, because it was a statutory language. The judge used the most recent statute instead of the older statute. And he said, fine, forget it. I'd rather not have it in there. So at the very end, counsel agreed. We all got together and we agreed that this was the instructions for the jury. No objection. You would figure if I know I looked at all the jury instructions to make sure the jury instructions that I wanted were in there. We forgot an instruction on damages. We got 0. We got $1. That's it. We didn't get any damages because we forgot to put it in there. That's fair. You waive it. That's what all the cases say. If you're going to object to it, the time to do it is then. Not later on, not 30 days down the road in some sort of post-trial motion when you figured out, well, hey, we lost, and now we've got to find some way to, to get an appeal. No, you object contemporaneously with the error. Should have been recognized. It wasn't. An adverse possession, even if you find that the judge should have submitted that to the jury, it's harmless error. He gave you the elements that they were able to prove, that they bought the house in 1982, right? And that they, let's see, I want to make sure I get it absolutely right for you. That they owned the lot since 1982, they deranged the title from the original developer, this is all in the statute, and that they openly and notoriously occupied and maintained the disputed fee that we know of from 1982. We don't know anything before that because nobody testified as to prior to 82. So therefore, the dad case can't apply. There's no evidence to show that the dad case would apply. Since 82, what they're doing is they're missing one essential element. If you do it without color of title, right, if they're arguing without color of title, then they have to file a tax return with the Department of Treasury and the Property Appraiser's Office. That's not in the record. It was never done, so they can't do it without color of title. So now they have to do color of title. And there has to be some sort of document that's filed with the clerk, and the case law says other than a warranty deed, that shows that they own that piece of property or they took possession. That's the difference between the dad standard and the standard that's around today in the statute. They have not provided that essential element. So essentially, what they've described to you is they actually physically trespassed on their property without intent to get adverse possession.
And that's a significant difference when the statute was amended, correct? That you
Right.
had to have the written documentation to go along with your open and obvious, correct?
Yes, something other than the warranty deed. You can't apply the warranty deed because everybody's got the warranty deed. They needed something other than the warranty deed to show it.
And I know there was a dispute at trial between the appellants seeking to use the pre-statute elements versus your side, which was looking to use the post-statute requirement of the written, correct?
Right. And either way, there wasn't any evidence to show what happened prior to 82. Who put the fence up? How long has it been there? Was it permissive? Those people didn't testify. The previous owners didn't testify of either property. So there wasn't any, you couldn't figure out what happened before 1982, where the residents there were able to testify as to what happened from 82 on.
Is there like oil or gold on these 4 feet?
I was joking because it's the most expensive piece of property probably in Oakland Park at this point. It is a waterfront piece of property, and that's what's important. In equity, you're looking at if you have 4 feet of property, prime property, you're looking at the lake, or you have 4 feet on this side that's not prime property, and it's in the corner under a tree. So it's definitely a distinction. That is a nice piece of property. That 4 feet is, it doesn't have gold under it, but to my clients, my clients had two issues. One is that it's a prime piece of property, and second, if they ever go to resell it, they want to make sure that the title's right. So that's why they spent the money to do the quiet title.
But putting aside the requirement of the statute about the written document, is it fair to say that how this came about was your clients came to buy this property, noticed that this slab, this shed, and this, I think it was a heater, they eyeballed it and said, gosh, that looks like it's too close to our house. And that's what prompted them to move forward, have it surveyed, and set this cascade in effect, correct?
Well, not necessarily, not in that order. I think what they did is they had a survey done. The survey came back and they looked at it and they said, wait a second, that shed, that water heater is on our property. So what they did is they went back to the title company. This is Gus Carrott that testified at the hearing or at the trial. He looked at it, he called Target Surveying back and says, hey, come on back. There seems to be a problem here with this.
And remind me, was this pre-purchase or post-purchase?
This is pre-purchase. So my client wanted to make absolutely positively sure, and that's why they came out there 3 times to determine that 4 feet, to make sure, okay, that is our property. So they bought it, knowing that that was their property, and they would work it out with the neighbors. And here, in this case, I cited quite a few cases that, without the objection, without placing some sort of objection on the record, coming back later on and saying, hey, we didn't get an opportunity to have, have an opportunity to have our instructions on adverse possession heard. Well, that you can't argue 30 days later that you didn't have it. Now the jury's gone. That's why these cases all say, hey, you got to do it then, contemporaneously, so the judge can deal with it at the time. So what's the remedy? You go back and you have to retry the whole case because counsel
Well,
forgot?
even though there wasn't an adverse possession instruction, it was argued during closing, correct?
Right.
How was it argued without an instruction to accompany it?
I was the only one that brought it up in the record.
Anything else, counsel?
Yeah, one more thing, and I think it's something that wasn't touched on. Oh, even if the instruction on ejectment wasn't provided, right? I went through the harmless error part, but also the count 4 was injunctive relief. The court also granted a permanent injunction from them being on the property. So even if the ejectment doesn't fly, they're already off the property. One, so what do? Is we allow them back on the trespass until we can get the proper ejectment? And then also we have the injunctive relief, which was already granted as well, not a part of the appeal. They haven't appealed it. They haven't raised it at all. So even if this court was to say, okay, well, ejectment should have been instructions, but it's harmless error, they already have an injunction. They shouldn't be there. Plus, the ejectment is a remedy. It's not it's the remedy that's already happened. They're already gone. We already know quiet title rests with my client from the Tyson case, so we don't ask them to come back onto the property only to be properly ejected. Thank you, Your Honor.
Thank you very much, counsel.
And I'd like to ask that you affirm the decision below, and we rest on our briefs. Thank you.
Thank you. All right, Mr. Gladys, you have 1 minute.
Yes, Your Honor. As I said, the law in this case is not in dispute. The 51 case of Aiken v. Godwin from the Supreme Court of Florida says you do not permit a change to an original survey based upon a subsequent survey, which is the target survey. Some of the things that were mentioned in his argument, equity doesn't have any role here. This is real estate. You have people that bought lots in this subdivision based upon a plat and platted boundaries, and those boundaries are over 60 years old. And in fact, with regard to the instructions on adverse possession, counsel appellees never got their instruction read. There was absolutely no instruction read. And I dispute a lot of his factual statements. Our expert Robert Allison's survey corresponds with the plat survey, the original survey. It shows the occupied boundary lines as being located where the original survey shows them.
Thank you, counsel.
And that's summary. Thank you, Your Honor.
Thank you very much. Okay, the next case